Well, good morning, everybody. My name is Stephen Wood. I'm the director of the Center for Law and the Environment at the Allard School of Law in the University of British Columbia. Welcome to our second no-fly zone event of the 2021-22 academic year. The No-Fly Zone speaker series brings legal thinkers and actors from around the world to speak virtually about pressing environmental law issues. It fosters national and global knowledge exchange without generating travel-related greenhouse gas emissions. Today, environmental lawyer Roda Verheyen will join us from Hamburg to speak about the landmark decision of the German Constitutional Court earlier this year, holding that the German Federal Climate Protection Act violated basic rights because it postpones high emissions reduction burdens until after 2030. In our last no-fly zone webinar on September 27th, Australian lawyer David Barnden spoke to us about the landmark Sharma ruling that the Australian government owes a duty of care to protect young people against injury or death by reason of climate change. Today, we will look at the flip side of a governmental duty to protect people against climate change, and that is citizens' right to a stable climate. We are situated as uninvited guests on the traditional ancestral and unceded territory of the Musqueam Nation here at the University of British Columbia. Indigenous peoples steward much of the world's remaining biodiversity, bear the brunt of the worst impacts of climate change, and are at the forefront of movements for climate justice. We're grateful for their leadership, and we support their struggles for decolonization. Today's talk will be recorded, and the recording will be available on the center's website. Just a note to the audience, if you have questions, please type them into the Q&A bubble at any time. You can see the questions as they're posed and upvote ones you like. That is, if we put the settings correctly. I hope we did. After Rhoda is done speaking, I'll moderate a Q&A session. As we're a relatively small group, we will see if it's possible to call on people to pose their questions live. Our speaker, Dr. Roda Verheyen, represents the young plaintiffs in the German federal climate protection law case. She's a partner in the law firm Günther in Hamburg, which specializes in environmental and energy law. Before working as a lawyer in Germany, she worked internationally for various environmental associations. With her firm, she has filed several important climate change lawsuits, including one by a Peruvian farmer to recover a portion of the costs of adapting to climate change from Germany's largest electricity producer, RWE, one by family farmers and Greenpeace, challenging the German government's reneging or failure to adhere to a cabinet decision to reduce greenhouse gas emissions by 40% by 2020. A third is the People's Climate case before the European courts, brought by children and families from 8 countries seeking to compel the EU to achieve more stringent greenhouse gas emissions reductions. And today's case by German youth, in which the court ruled that the federal climate law violates Article 20A of the German Basic Law, Grundgesetz, which protects the natural foundations of life in responsibility to future generations. In addition to lawsuits, she also leads complaint proceedings at the Aarhus Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters. And she advises clients in many environmental cases from other jurisdictions where German law plays a role. Please welcome Roda Verheyen. So over to you, Dr. Verheyen, and thank you so much for joining us.
Yes, good morning or good evening, as it is already evening here. Thank you for having me. Hello, Stefan. It was nice meeting you years back, and I'm glad to be able to shed some light on the decision. for the Canadian audience. And as you said, it is a landmark decision. I'll try and speak about it, but since we're in completely different jurisdictions, I think some of the Q&A will actually be more interesting, especially to students, to try and compare what has gone on in Germany and what might go on somewhere else in other jurisdictions. Just while I start my presentation, just a few words. Thank you for the kind introduction, Stefan. I haven't always been a climate lawyer. I'm no such thing. There is no such thing formally in Germany. I'm just a lawyer in a law firm, but we are specializing in environmental and planning law, but also in energy law. So we also develop lots of renewable energy projects and other things that are very practical. So some of what I do, or very much of what I do, is always informed by what my colleagues do. And you see my colleagues here. If this can be seen, can you? Yes, Kira is nodding. Good. Okay, so you see myself and my clients, my colleagues here. So I'm going to talk about the Federal Constitutional Court's landmark decision on the Climate Change Act. And before I do that, let me just give you a few basic kind of understanding remarks on the German system. So we are a statutory system. We have a constitution, which is the basic law, the Grundgesetz. And the Grundgesetz contains both the human rights catalog in Germany and everything to do with jurisdictional, constitutional issues between the federal state and the Länder, which are the states, everything to do with financial matters, with the courts, with everything to do with the state in particular as a whole. So our Grundgesetz is very complete, as it was only drafted after the Second World War with the help of scholars from all over the world, actually. And we're very lucky to have it. And we're also very lucky to have direct access to our Constitutional Court. And that's what we did. We took that route, which is normally very cumbersome. About 99% of all constitutional complaints in Germany are actually rejected at the outset. But we were lucky, and I'll talk a bit about that. And I can speak a bit about the other case that Stefan kind of mentioned before, which was actually the predecessor to this one. So let me just give you a quick timeline. So obviously, Germany has always been a good player in climate politics for a long time. Climate policies in Germany seemed to work for a very long time, including after the Kyoto Protocol came into force and even after the Paris Agreement was signed. Everybody thought that Germany was going to be the good guy, or in the good guy corner anyway. In 2018, around the time where the first results of the IPCC special report on 1.5 degrees became public, it also became public in Germany that Germany was not going to reach its own goal for 2020, which was a 40% reduction over 1990 levels. And we took that to not the Constitutional Court, but it was a case against the executive, the government, in an administrative law court in Berlin. And we argued many of the things that everybody is aware of in most climate lawsuits. We argued justiciability. So can a court even rule on these issues at all? We argued, is this climate protection anything tangible in our human rights catalog? We talked about the carbon budget. We spoke about the way in which individual plaintiffs could even go to court, so admissibility. All of these things were already in the court in 2019 in Berlin. But the case was ultimately rejected. All of the important questions were answered in the affirmative. Justiciability, yes. Climate change is a human right in general, yes. Individual plaintiffs can claim, yes. But in this particular instance, because there was no law, the court found itself unable to actually declare that the government had violated these rights. So then, at the same time, 2 months later, the first German climate law came into effect. That it contained the same 2020 target that we had been going on to court for, slightly altered, but it's essentially the same. And it also contained other targets which were entirely outdated and insufficient. So because we couldn't actually continue the administrative court case at all due to legal reasons, we then decided to actually take the climate law to court itself for insufficiency. And we won it, as I think everybody slightly interested in climate litigation in the world now knows, in April, the decision was actually dated already in March, and it is a landmark decision. It is essentially the first decision of the Federal Constitutional Court which has environment, the next generation, protection duties at the heart of it, and it contains a huge amount of very useful facts and figures and a recognition of the carbon budget that is extremely useful in any jurisdiction, I would say. And it was published to the absolute surprise of everybody involved in this case. I can only explain remotely what it meant to people like me who have been dealing with these cases for a very long time. So essentially, these were the plaintiffs, and I should say there were 4 complaints altogether. I took one of them. These are the plaintiffs of that first case in the administrative law court, including also one plaintiff at the top left corner from the European climate case, which Stepan mentioned, and also included in the middle there, Luisa Neubauer, who is an activist with Fridays for Future. So these youth and young adults took that case to court, actually arguing that there's an insufficient protection level from the Federal Climate Protection Act. We argued the human rights that are set out here from our basic right. They're slightly different, obviously, in the human rights catalogs of various regional and state constitutions and also international treaties. But we have essentially these, so human dignity, health and life. Health and life is everything to do with health and life. Human dignity is a very open concept and it is invoked very rarely. And I will explain what we did with that. Vocation and property, because we had essentially young farmers and tourist families behind these youth. So all of them, to some degree, except for one, argued that they were actually being impaired in their whole life choice by climate change and its effects. So the legal claim was that the German Climate Change Act of December 2019 is insufficient because there is no reduction pathway leading to 1.5 degree or even 2 degree, and the budget is completely exceeded. The legal argument was one of the duty to protect. So on the one hand, it was the duty to protect as a bit of a novel concept of human rights law, but also of active interference, because we argued, such as we already did in the European complaint, the People's Climate case, that by setting out reduction budgets for various sectors in the climate law, the government was essentially allowing a level of emission that was too high. So we argued both sides. Essentially, an omission to take more reduction measures is the flip side, like in a coin, of actually not protecting enough. So what we then argued in the gist of it was that the guarantee of human dignity in Article 1 is affected because the generation of the complainants is deprived of any options for action to protect itself. They need to remain in control of tipping points, and that means that the government, and any government actually, now has to do as much as it can. And also a reduction pathway, the reduction pathway in particular of this act was just completely insufficient and violates the fundamental rights to life and physical integrity. And using the agenda and Article 2 and 8 of the European Convention of Human Rights interpretations, that kind of featured as or filling out the duty to protect. You have to understand that the agenda lawsuits in the Netherlands have nothing to do, obviously, with the German legal system, but because they used European human rights arguments, we could invoke them as arguments, not more, because the European Convention on Human Rights has the same effect in German law as a normal law. So it's not the same as our constitution. We can discuss that later, but that's essentially what we did. So the admissibility was obviously the main hurdle, as it was or has been in all of the US cases, including also the one in Canada, as Stefan has just explained to me. So this is not the same in my mind as the justiciability issue. In all of the climate lawsuits in Germany, the government and the legislator, which is the Bundestag, argued non-justiciability. Essentially, that issue is finished in Germany. There's a complete lid on it. Nobody's ever going to successfully argue that again. But admissibility, and that was already done in the administrative court in Berlin. But the admissibility in this instance was a huge hurdle. Under the German procedural law that governs the constitutional court, applicants must substantiate what fundamental rights are infringed and that they are personally, directly, and presently affected. Every single jurisdiction has some sort of formula that contains similar strange terms that need to be filled out by the jurisprudence. So the Aarhus Convention does not apply. That's, I think, not so important for the Canadian listeners, but obviously for European ones, since this is a UN ECE convention and doesn't apply to Canada. So essentially, that's what I took out from the judgment itself, what you can read here, and I'm not going to read it all, but essentially it just said, the court said, well, because of the overwhelming majority of science and scientific facts showing that there are huge risks of health impairment and risks to life, at least the duty to protect could have been impaired. And that is the admissibility hurdle that we always have to meet. We need to always show in practice in the court that some right could have been impaired, and then the court moves on to the merits, right? That's also to some degree the same in every jurisdiction. And that's also the main reason, for example, why in the European climate case, the European Court of Justice actually declined. It said that we hadn't actually met the admissibility requirements that stem from Article 263 of the European Treaty. So, and it goes on to say, these are not inadmissible actio popularis, right? And it then mentions the VG Berlin, which is the Administrative Court of Berlin, the one that I was talking about before. And then it says something very important. It says, it is not required that complainants are especially affected. It doesn't mean that you can't claim if everybody is affected. The mere fact that very large numbers of people does not exclude persons from being individually affected. Obviously, that's a hugely important statement for any climate lawsuit taken against the state. Let me just hear. So the key findings. The fundamental right to life and physical integrity, which comes into this equation through Article 2. Remember, I was talking about Article 2, life and health, includes the duty of the state to actively protect life and health. I know that that is more than some of the regional and national constitutional courts or courts at all have been willing to actually say, but this is not a deviation of the standard formula that our constitutional court has used. It then goes on to say this is not a fundamental right of future generations, but of persons alive. This obviously is the whole of the problems that arise when people act on behalf of future generations unborn, right? And that is a dogmatically hugely difficult problem. It then states that the state has a wide margin of discretion, right? And there's no infringement at this point. So from the impacts of climate change, which I put there, essentially, there's no protection duty infringed at this point. Why? Because the worst impacts might still be adapted to, essentially. The mentioned Article 20A of our Constitution, which essentially is a state doctrine to protect the natural basis of life, also for the benefit of future generations, that is not a fundamental right enforceable. So you cannot actually go and claim Article 20A directly. But it does impose a duty to achieve climate neutrality. And so through Article 20A, and such a duty on the state is actually in existence in some other constitutions as well in the world, the court kind of flipped the Paris Agreement on its head and said, well, actually, if the Paris Agreement sets a universal problem and defines the solution as climate neutrality by 2050 or around that time, we'll just put that into our constitution now. That's what they did through Article 20A. And the duty to protect itself is justiciable, and that means, and it limits political discretion. And therefore, if you relate number 2 to number 1, you know what's happening now. They essentially apply Article 2 or any other fundamental right, and the standard becomes Article 20A. So obviously it does not, the duty to protect the climate it limits political discretion. It doesn't take precedence over constitutional rights and other principles. This is very important because this is now invoked by courts, for example, to actually allow them to still permit lignite mines, for example. Yeah, so there are other interests we still have to weigh, but climate neutrality is a fundamental constitutional target and standard now. So the Climate Change Act itself is unconstitutional. I should tell you a little bit about that. It contained a 55% reduction target by 2030, and that's it. There was nothing else in it, essentially. Lots of aspirations on climate neutrality, but for example, no actual climate neutrality target and no targets beyond 2030, and certainly no carbon budget implied. So essentially the court then takes the climate science. It says, well, it's quite logical, people, that we have an absolute limit on what we can still emit. So there is a carbon budget. There's also some sort of share of Germany that applies here. We don't quite know where that might be, but it is probable that based at least on equitable distribution per head, it would be X in this particular instance, 6.7 gigatons of carbon. And that can be shared by everybody around, but also by other generations. So that's the next sentence. So based on Germany's targets, the emission levels that the Climate Change Act allows until 2030 would use up a large part of the total emissions budget. And that is the actual infringement of rights. So that's the fourth one. The state has a duty to take precautions in order to protect fundamental rights post 2030, right? It has to initiate transition. And that means that the Climate Act itself was really unlawful because it did not contain any targets after 2030. It is really important to understand what this means. It means that the rights infringement was not based on impacts of climate change. It was based on the impacts that drastic and sudden climate protection measures taken by a state would have on future generations. So the vision that the court also sets out is actually one of climate protection measures impairing rights. That is something that none of the applicants had actually argued like this. And I still believe that it actually puts a very strange emphasis on things. But I understand what the court was doing. And I understand why this is also important, because it preserves a very large margin of discretion in the eyes of the court. If you read the full decision, you will come to the conclusion that yes, the targets for 2030 are insufficient. And yes, there are hugely important impacts to be feared. But formally, the reason for the success of this case was that there were no targets after 2030 in our climate law. So what about the EU? I've already said that this is vastly different from what the European courts did. they essentially said, if everybody is affected, nobody can go to court, which is wholly unconvincing to me. It means that there is no human rights protection in the EU in cases of universal effect, such as climate change, but could be anything, could be antibiotics, could be nitrate levels in groundwater. Anything that affects large numbers of people means you cannot go to European courts. That's a very sad result. And there has been, these are the plaintiffs from the European climate case, the People's Climate Case. Obviously, they were all very disappointed, but in the end, the case to some degree already won, because we now have in Europe the intent by the Commission and the states to actually reduce emissions much more than was set out in the Emissions Act that we went against. So in substance, actually, what we're now getting is what we would have gotten through the climate law case as well. However, in terms of admissibility, obviously that's a case for discussion. And also, and what also can still be influenced by the German case that I just discussed is the European Court of Human Rights, which you can see here. We have, as of today, 4 cases notified. One, and there's only 3 here on the slide. One is the Swiss ladies case against Switzerland. One is the Duarte or Portuguese children's case against 33 contracting states. One is against Norway about drilling in the Arctic and taking into account the Paris Agreement there. And the 4th is one against Austria. The Duarte case involves Germany as a defendant, and we've just seen the responses by states in those cases, in specific in that case. And if the European Court of Human Rights decides to come to a bold decision, which everybody hopes it will, it could actually flip around the assessment of the constitutional courts that I've just relayed to you to some degree, because there is no such thing as a firm limit or line between protection duties on the one hand and interference on the other in European human rights. So it remains to be seen what happens in that case. All of these cases, as I said, have been notified to the respective defendant states, and there will be a judgment of some sort. And I can only hope that this court will take the route advised now by the German Constitutional Court on admissibility and actually look at the merits. I should say that these cases are very different from our Constitutional Court case because they don't look at one particular law. All of them look at the entirety of inaction or the general reduction pathway, and none of them actually looks in concrete at a particular law like the one that we had in our focus in the Constitutional Court. So that's it, and I'm happy to answer any questions that might occur.
Thank you so much, Rhoda. I think I can safely remove my mask. I'm ready to moderate some questions, and I'll look at this Q&A to see if we've got any. And while we're waiting for Q&A, maybe I can get things rolling with a question of my own. Really, I think it relates to a point that you made, the surprise in the Constitutional Court's ruling that the focus on the violation of freedoms was not the freedom of people to be free from the impacts of climate change, the bodily integrity and the life and the dignity, but it was the sort of civil liberties to engage in carbon emitting activities that would be disproportionately restricted in the future by climate protection measures. And I was really intrigued by that. And the court even uses this term of radical abstinence to describe what might be required of future people if the burden of reductions is pushed forward after 2030. I just wonder, does this approach have a precedent in German law? And what do you make of it? How do you think it might influence future cases or future decisions?
Well, first of all, there's obviously now a huge amount of discussion going on in the academic circles and the journals about this. I can only say that there is some writing to the effect, some of it is referenced, some of it isn't referenced. I believe that there's a motivation, or one of the motivations of the court was to really keep to the traditional theory of human rights, rather than to extend the protection duty. And also, given that this is a unanimous decision, there was a need to actually find a solution which, to the mind, I think, of the court wouldn't open a huge Pandora's box. I don't think I can think of ways to argue this decision in the same way without this type of construct. But I also think that there is value to this concept because, as I said before, I argued that there was a interference with human dignity because youth would not actually be a subject, so making their own decisions anymore, but an object. So to some degree, this is actually the same, but not due to impacts of climate change, but due to restrictions in travel, in communication, in just life choices generally. So I asked, when I read this, I asked myself, so is this really so different? I think the only difference is that there is a state in between. The state assuming, or the court assuming that the state will have to take such drastic measures. And that is actually logical because the state would have to take such drastic measures. Otherwise, there would be an interference with the obligation to protect. So again, the flip side to everything being interference or an omission in terms of the duty to protect is actually adhered to. And there is if you look at that logic, it makes a lot of sense that the court adopted that reasoning. Obviously, I wasn't in the courtroom. I can only say that this is a hugely important decision. And it was obviously a massive task for the court to actually come to a unanimous decision on this one. I think it shows, one, that they felt there was a need to actually rule on climate because the arbitrariness of political decisions just doesn't work. They needed to set the framing right, and the framing being you have to go to zero within some sort of non-arbitrary carbon budget is a very important one. So I believe that's what they wanted to do, and they did that. And I'm very grateful to live in Germany and to be able to actually have such a court. I mean, I haven't seen anything remotely well-reasoned anywhere else in the world. Yeah, in the world. I'm sure I haven't read all of the judgments, but
Yeah, I actually, I was really struck by that. In the decision, the court effectively said that anything less than a law aimed at carbon neutrality would violate the rights to life and
yes,
bodily integrity. So that's a pretty fundamental statement from the court.
yes,
I actually see
absolutely.
we have some questions now. The first question is from David Driesen. Welcome, David. And he's asking, can you say more about what justiciability means if it doesn't mean the requirement that plaintiffs be personally impacted, which you said was pertinent to admissibility. And I think that's what in North America we would refer to as standing. So maybe could you just speak a bit more about the distinction between justiciability and standing or admissibility? Yeah.
Justiciability as an issue procedurally does not exist in Germany. It does not exist. There is no, we don't have a political doctrine, theory. We generally have very few headings in procedural terms that could actually justify looking at justiciability. I think what this really means is the margin of discretion. in the merits. And that's what we also argued in the administrative court in Berlin. It was very interesting to see what happened there, because we made this huge presentation of the carbon budget and how kind of not meeting the 2020 target doesn't actually just mean a point in time, but it means actual tons of carbon, and that we then have to. So we actually presented all of this evidence. We then argued on why the target itself became binding, also through the same basic rights that have been invoked here. And the government essentially only argued on justiciability. They didn't, because they couldn't refuse the fact that they weren't meeting the target. They couldn't refute the fact that actually the target had no reason, no budgetary reason at all. So what they did was essentially only argue justiciability, and the arguments there were very much the same as the ones that you normally see under margin of discretion. Yeah, on admissibility, there was also some overlap, because as I said before, the standard that we have to meet in administrative law is that you have to invoke a subjective public right. That's very strange. Nobody can understand that. It essentially means that you have to find a provision in a law that is actually meant to protect you, and not everybody, but you. So this is the kind of the bar against an actio popularis and against everybody taking everybody to court. But obviously it's an open concept, and there's an immense number of rulings on what this means and why, and essentially both in the administrative court and the constitutional court, what we presented to the court in terms of impacts and rights. So who are these plaintiffs, what are they doing, and why are they affected? Yeah, that was sufficient, by far sufficient. We didn't even have to really discuss it. And that's going to be, this issue is going to be now very interesting, because we're currently preparing suits or claims, briefs to court against Volkswagen, one of the biggest emitters in all of Germany, if you take all of the emissions from the cars sold. And there, obviously, we will have to argue that in a horizontal setting, in nuisance, people can actually also exercise these same rights. And that then becomes a very different level of discussion on justiciability in front of civil law courts. There's also another level that's interesting, because actually our climate change law includes a provision which says this law is not meant to protect the people. So the people cannot actually invoke the enforcement of the targets. That's currently in court. I think that has no meaning, and I don't think this can be remotely true. I have no idea what's going to happen if the court that's Berlin, Brandenburg, it's high administrative court. If the court actually finds that to be enforceable, then it at least has to allow environmental associations to enforce the targets. But that remains to be seen. So we don't know yet what's going to happen with that, and how the judgment now from the Constitutional Court will be interpreted in that sense, in the enforcement sense.
Thank you so much. I wonder if I could ask a quick follow-up on this same issue about admissibility or standing. So there's a big difference then in the decisions of the German courts and the European court in the People's Climate case. What's the legal basis for the European court's rejection of standing? And is the legal basis really so different in Germany and at the European level?
Sorry, I was muted. Sorry, I clicked the wrong button. Well, let me tell you what the legal basis for the European Court's decision was. The Article 263 of the European Treaty on the functioning of the European Union contains a provision which explicitly allows for persons to claim the illegality of legal acts. So in theory, the legal acts of the European Union are directives and regulations and decisions. So the treaty explicitly allows people to actually claim in court against those. And it contains a similar formula to the one that we've already discussed. You have to be presently affected, personally affected. I don't quite know the formula now, but it doesn't matter. It's essentially the same. However, there is jurisprudence dating back to the 60s, the so-called Plowman formula, which essentially interprets that treaty provision to mean that you can only claim against legal acts if you are affected as though you are an addressee. And that obviously narrows down the cases immensely. And I think that's what is wanted. However, the problem has become apparent since 2009, since we have received a European Charter of Human Rights, and the European courts have said repeatedly that they are the ones to interpret and apply that charter. Now, I wonder how are they actually going to do that if they don't allow claims? And that's what I criticize. I find the European jurisprudence and especially the Court of Justice to be extremely important. And I'm a complete European. I find that the European Court has done more for the environment than probably all of the national courts combined in the past 20 years. But on this particular matter of actually letting citizens ask for human rights protection, there is no solution. They haven't got a solution. And that means that people now go to the European Court of Human Rights in Strasbourg, which is not good, really, I think, because it actually doesn't strengthen the European courts, the European Union courts. But that's a matter of political discussion, and I believe I'm not even sure that this is even going to change very soon, because the European Court of Human Rights will continue to do its job, and the European Court of Justice can simply say, well, if there's really a human rights matter, let the national courts refer it to me, because that's what normally happens, right? In the EU, the national courts refer questions of European law to the European Court of Justice. But I still think there's a huge gap, and it's really not honest the way the system works. I've said this many times, and again, I stress it again, I'm a huge fan of the European Union, but there is a gap. Yeah.
Thanks. Well, we have a good queue of questions coming along now, so I'll go to the next one. It's from Austin Earhart here at the law school, which the question is, do you have concerns regarding how the government might adhere to the court's orders, for example, taking just minimal efforts? Does the ruling impose a sufficiently clear and strict mandate on the government? And what remedies would be available if the government fails to live up to that mandate?
Interestingly, the government claims to have already transposed the judgment because they've already adhered to it in terms of adopting a new law. The law has been changed. It has come into effect in August, and there are now the following targets in the law: a 65% reduction by 2030, and very kind of numerically spelled out. There's also targets until 2040, and there's now a neutrality target for 2045. And overall, that judgment is only slightly altered with respect to actually how the budget is used up by 2030. But formally, there are now targets after 2030. The remedy to actually look at whether this is constitutional or not is to go to the Constitutional Court again after the time it has set, the time limit for adhering to the court order has been used up, and that's by the end of next year. So we can look at it, and yeah, and the question then obviously is, how can we make sure these targets are actually reached, that carbon neutrality can actually be reached by 2045 is not a matter of paper or targets on paper. It's a matter of actual measures and actual transformation. And that's something that we'll all have to deal with in the future, including also in the European Union, because we are now in the process of adopting a whole new body of law in the European Union, which also has to be enforced. Yeah. Also, in that context, obviously, it's important to note that there's not just Germany has received climate litigation orders, but there's now Netherlands, Belgium, France. Well, Ireland is a bit different. So yeah, there's these the need to adhere to climate targets, I think, is now recognized in Germany, in all of the EU. Sorry.
So I was just going to ask a quick follow-up on this issue of the mandate that has been given by the court. Can you just help us understand, do you think it was just a purely procedural order to set targets post 2030, or does it really have substantive content in that the target for 2030 needs to be strengthened so that less of the carbon budget would be used up by 2030 and less of a burden is imposed on people post 2030?
I think there are two answers to this. If you look at it formally, purely formally, the actual order only refers to targets post 2030. But if you read the decision, if you actually accept and acknowledge the decision in its entirety, which is tradition in Germany, then the former is also correct. And I mean, this is now going to be a topic of interpretation in many shapes and forms. And there's a danger of interpreting this judgment in very different ways. But I think the importance is it sets the guideline for anybody in the future that we actually have to come to climate neutrality in a very short time span, and that if we don't get there, there is automatically an infringement of the duty to protect. And there's a very important benchmark. And I would even say, through the way the court has come to that conclusion, you could even apply that to any state in any context, in any human rights context. If obviously there is a possibility of actually claiming direct adherence to life and health and all of the other freedoms. That's another interesting one, actually. What kind of freedom is at the heart of this decision? It's actually quite unclear to me, anyway, reading it. I have my own interpretation, but I have read many others. So it's a bit of it's everything, life choices, everything. And that's obviously something that is not particularly protected under every constitution to the same degree. No.
Yeah. Well, I'll move on to another question. Thank you very much for that elaboration, though. So the question that we'll go to is from Paul Johnson here at the law school. How large a role do you think the German constitutional right to property played in the case? It's a right that Canada does not expressly protect in its constitution, while the US does. So do you think that constitutional rights to property help to encourage more people to undertake climate litigation beyond people who might identify more traditionally as environmentalists?
In this particular decision, Article 14 is not very important. Article 14 otherwise has a very high importance in German jurisprudence. And that's actually interesting because it is not absolute. Our constitution says the property is protected, but subject to laws and subject to social acceptance So it's not as if this is a completely capitalist country where if you own your, you can't own your daughter, or you don't own, you can't even own a piece of property without being regulated. For example, you can't own a beach in Germany. So it's not an absolute protection of property in all shapes and forms, but it has a very, it has been penetrated with respect to actual reasoning to a very high degree in German law. And it also is in contrast, or stands in contrast to expectations, economic expectations, which are not protected by our constitution. So because of that, because, whatever you might have made in terms of sales in the future, if you had full access to your power plant, for example, is not protected by the constitution, there is a need to actually then look at what is protected under Article 14. And to the question whether I think that other people have become more enthusiastic about taking climate cases, I'm not sure about that, but what I'm currently doing, obviously, is I have, there's lots of people actually interested in invoking some sort of law to protect their property. We've just had huge floods in Germany that have led to 30 billion euro of economic damage, and we are looking at this problem now. There's simply a huge amounts of property damages to be expected from climate change, and that's even accepted by our constitutional court now. So that becomes more important there. Whether,
Yeah, you can also think about the massive amounts of property damage due to wildfires in the last few years in Southern Europe, in Canada, the United States, Australia. Interestingly, in the Sharma case in Australia, the court rejected property damage as a basis for the government duty of care for various reasons. And at the same time, in South Africa right now, there is a proposed constitutional amendment to the property rights to say that property can be expropriated without compensation in certain circumstances. So it's really interesting to compare things that are happening with property rights in the context of environmental emergencies all around the world. Next question comes from Winona Klempt, and it's a very simple and pointed question. In the German Constitution, is there a specific duty to protect young or vulnerable people?
No. The only provision that could come close to that is Article 20A of the Constitution, which is a state objective, and that was now used to create the standard and to actually inform the Constitution that one of its unwritten aims is climate neutrality for the benefit of future generations. This whole constitutional judgment doesn't look at vulnerable people in the South or the North. I mean, obviously, the plaintiffs from Bangladesh who were also there have been a topic of the judgment overall, but everything to do with equity is very short, very, very short on that judgment. But that's because the topic of the whole thing wasn't climate change in general. It was our particular law, which only looks at in the inventory of Germany and only with respect to sources, not even with respect to sinks and land use change and everything else. So yeah, only a snippet of everything.
Well, thank you. So the next question is from Chris Tollefson. Good day, Chris. Thanks for joining us from the University of Victoria and the Pacific Center for Environmental Law and Litigation. Chris says, you mentioned that the notion of fair share related to and derived from carbon budgets seems to have gained some traction in this judgment. Is this fair share concept now one that has constitutional status in German law?
That's a very difficult one. What I always say is that this judgment renders constitutional status to the need to come to carbon neutrality within the limits of a sound carbon budget. I think that that is actually contained in the decision. Whatever the fair share is at least not explicitly stated. What is stated explicitly is that no state can argue that it shouldn't be obliged to do anything because somebody else is not doing its share. So in that sense, in the fair share sense of the Ogenda judgment, yes, it is stated, and that also has constitutional status. But with respect to what the fair share is exactly, there is some room to maneuver. The question right now in Germany is there a need to actually set a budget? And that's one that remains open because the government hasn't set a budget. It hasn't declared a budget. You can only partially deduct the budget from the new climate law. I think that there is actually a need to set a budget, at least a approximate one. Naturally, the carbon budget is a concept which has uncertainties on all sides. But I think there is a need to set a carbon budget simply because otherwise you can't adhere to the order of actually having a generational or you can't adhere to the task that was set by the Constitutional Court to weigh all interests, including the generations to come, to actually rule out the possibility of this drastic and abrupt halt. How can you do that if you don't actually define what the budget is and when such measures might have to come and fall in place? But that's my interpretation. To be very fair, this is open for other courts to decide, open for me to argue, for somebody else to argue.
I will ask one last question, Rhoda, and it's from David Driesen again. I think it really reflects the sort of situation that we in Canada and the United States find ourselves in when trying to get courts to order governments to do things. So in relation to climate change. So he asks, how did you persuade the court that it must order the government to set targets for actions that won't take place for another 9 years?
If that is a strategic question, I think the answer is climate change was at the forefront of everybody's mind in Germany. Again, if that is a strategic question, we had some of the topics that were necessary to actually make those decisions and the whole of the facts. We had that in court already beforehand. If it is a formal question, I just think nobody can answer that. I honestly think that the science that we had in Germany at our disposal to actually give to the court and to not only the pure science, the IPCC science, but the distilled science, I always say, the distilled science that have run through all of these institutions in Germany that are important and creditworthy and trustworthy and all of the rest, that was the decisive factor here. In essence, it was one paper rendered by the German Council on the Environment that actually looked at the carbon budget in simple terms. And so if you ask me if it was me and my colleagues from the law side or the science people that put their heads together and were brave enough to put out those papers that made the decision here possible, I would definitely say it was the scientists, not us, at least not alone at all. And I can only reiterate that it was also a matter of huge amounts of work on the part of the court to come to such a decision in a unanimous way. in that, just I have the highest respect for this court that has just turned 70. So, yeah. Okay.
Well,
Thank you very much.
This is the point at which we must draw to a close. It has been so illuminating. The work that you and your partners and associates there at Gunther are doing is really inspiring. You've been at the forefront of the efforts to use legal systems to advance some kind of climate justice for years. And it's really a privilege to hear from you about this case and about the other work that you're doing. I think we in North America can really just hope that there are possibilities to emulate some of what you've achieved there over here. So I thank you very, very much. And I would just remind the audience that the session has been recorded. And if you want to refer to the recording in future, you will be able to find it at the website for the Center for Law and the Environment by just following the same link that you used to register for this event in the first place. So thank you so much, Rhoda, and carry on the good work.
Okay, thank you. Bye-bye.